Hello.
Yes, yes, thank you.
Okay. Here I'm back with a new webinar. Today I organized a webinar. The topic of our webinar is the practical procedure to file a criminal complaint. So let's get started without wasting our time. And our guest is Advocate of Supreme Court, Mr. Himanshu Jain. So, sir, welcome to our channel. And should we start, sir?
Yeah, why
Thank
not?
you so
Sure.
much, sir.
Right. So, hello guys. Today the topic is practical procedure for filing of a criminal complaint. I must say the topic is very heavy. Why it is heavy? Because generally वकील लोग filing करते नहीं हैं. When they do have their munshis with them, so they draft the complaint and they leave it to their munshis. Okay, you go and file it out. But as I have been called to share our views on this particular aspect, so before getting into the practicality, I must say that we should be looking towards that what a complaint is all about. A complaint कैसी होती है and how it should be like when you are presenting it before the concerned magistrate. So before getting into the technicalities of the same, I must read section 2D, which is very important. Section 2D of Criminal Procedure Code, which defines that what is a complaint. It says that complaint means any allegation made orally or in writing to a magistrate, whether due to this taking action under this code, that some person, whether known or unknown, has committed an offence but does not include a police report. अभी मैं explanation में थोड़ा बाद में आऊँगा, but first we just need to know what is this a complaint basically. It says the allegations made. अब this word is very important. क्या हुआ? I'll try to explain it with an example. क्या हुआ? I was passing by from a roadside. I have seen that a person is beating his wife. Right. So वो अपनी wife को मार रहा था. So I moved to the magistrate and I filed a complaint. Now the question is, what should I be writing in that complaint? Allegations. अब allegations कौन लगा सकता है? That is also a prime concern. Can I allege that particular person? The answer would be no, because I am not affected. I am not a victim to that particular aspect. अब इसके लिए उसको और समझना पड़ेगा. My last webinar on decriminalization of adultery, where we have discussed this point, that the infected person or the victim is the sole person who can file a complaint, because the concern of locus standi is paramount consideration whenever you file a complaint. अब मैं उस एग्जाम्पल को वापस से बढ़ा. अगर वो हस्बैंड अपनी वाइफ को मार रहा था तो who is victim? It's the lady herself who is the victim to that particular incident. So who can allege the husband? It's that lady only who can allege the husband. Nobody else. Because she herself is the victim and therefore she alone has the right to file a complaint and make the allegation. अब मैंने जो मजिस्ट्रेट के सामने complaint की, what was that? That was not a complaint in the law specific sense. That is mere information which is being given. And magistrate is duly empowered under section 190 clause 1 subclause C of CRPC for taking up cognizance on the information also. So that's why this word is very important. More or less, if you want to elaborate this word, allegations and information, I may suggest you that you should read the judgment of Jessica Lal murder case. That is Manu Sharma versus State, that is 2010 Supreme Court, delivered by Honorable Mr. Justice P. Sathashima. In para number 100 and 110, he has very categorically stated all the cryptic and non-cryptic information concept. So the information concept is very different to the allegations which have been. I'm not getting into it. I'm coming back to the complaint itself. Now, what it says, with a view to his taking action under this. अब I was passing by, husband was beating his wife. मेरा मानना तो था और मेरा कहना भी यही था कि हस्बैंड के अगेंस्ट में एक्शन लिया जाए. बट am I the right person who will tell to the court कि उसके अगेंस्ट में एक्शन होना चाहिए? आंसर विल बी नो. Why? Because मेरा ये कहना कि उसके अगेंस्ट में एक्शन लिया जाए क्या मेरा कहने को जस्टिफाई करता है? आंसर अगेन इज नो. So the better aspect, the better position, better point is that the first and foremost thing while a judge is dealing with the complaint or while you file a complaint is to establish your locus standi for filing that particular complaint. अब इसको मैं थोड़ा सा elaborate करूं. कैसे? I go to the registry. Registry is the place where complaints are being filed. I go to the registry. So registry क्या करती है? It's a mechanical work of registry they used to do. Registry क्या करती है? सबसे पहले they used to check the checklist. Okay, whether all the things are being done as per the norms which are being provided by the concerned High Court of a trial. Right. After checking this, they will be looking forward with the case information form. I'm telling you the Delhi, but for other states I cannot tell it for sure. क्या होता है कि you have to file a case information form along with all the complaints which you have filed. So for that aspect, you need to fill the details of the complainant. You need to fill the address of the complainant. You need to fill the age because as Delhi, there was an office order passed by Delhi High Court whereby the senior citizens or the aged citizens, their cases should be listed bit quickly then to the other persons. So for that aspect, you need to fill that. You have to fill the phone numbers so that the messages should be delivered on the concerned phone number, also dates and the timings of the case which is being when it is being listed. Then it's the email IDs, so that when the judgment has been pronounced, then the judgment without taking any money, it's called free of cost, shall be delivered or shall be sent to the email IDs of that particular person. Now, same is the case with the respondents. That complainant, when filing a complaint, must be knowing that against whom he is filing a complaint. Right? But 2D is very much wider than that aspect. Whereas, what do you call it as? The case information form is confined to that aspect that you need to give the details of the respondent, because as soon as the process has been issued against the particular respondent, the respondent needs to be served up. तो respondent को तो सर्विस कराएंगे. So इस चीज के लिए I will club with the memo of parties. Before moving to that particular aspect, I just swiftly finish the complaint part and then we'll be moving to that aspect. So what the explanation of, I'll just read it out again and I'll just finish it out. What it says, complaint is an allegation made orally or in writing to a magistrate with a view of his taking action against action under the scope that some person, whether known or unknown, has committed an offence but does not include a felony. Right, as we all know that section 190 clause 1 is the basis of taking cognizance by a magistrate. That means a magistrate has the power to take the cognizance only on the basis of 3 clauses which are being provided under section 190 clause 1. Therefore, complaint is a part that is, it is very much specifically dealing by virtue of section 190 clause 1 sub A. Right. So I'll be coming back what we were discussing at that particular. Okay, what are the basic contents of a complaint? जब registry के सामने हम किसी complaint को लेकर जाते हैं, so what are the things which we require to secure so that it should not be returned us back कि भाई इसको जाओ दोबारा ठीक करके और फिर वापस लो. It is we are just now we are just seeking only with the general offences, that is which are being prescribed under Indian Penal. The complaints which are to be filed under the provisions of Indian Penal. I'm just confining myself. For the specific offences, for special offences, I'll be dealing with afterwards. So what is being done in that case? So I'll be counting on my fingers that what is required. First, case information report. Second is the checklist. Third is the index. After index, it will be memo of parties. Then it will be list of dates and events. Then a brief synopsis. Then it's the total complaint. So these 7 things which usually we keep in mind while filing a complaint, and most importantly the locality, the power of attorney which we also see. So these 8 documents must be contained in every complaint, because if the complaint does not carry any of these things, I'm again specifying it that it is only for the courts of Delhi. That's why I'm confining myself to Delhi courts only, and for others, I'm sorry, I'm just skipping those things out. अब क्या हुआ? Now I'll be discussing each and everything in one more. First of all, case information. I just give you a brief outline of case information. The second is checklist. Checklist is more or less same.
सर कुछ कमेंट्स आ रहे हैं स्टूडेंट्स के, आपकी वॉइस क्लियर नहीं है, आप एक बार चेक कर लीजिए.
Right. I'll just check.
Yes.
Am I audible right now? Hello. Am I audible now?
Yes, sir.
Fine. Okay. So सबसे पहला document था is the case information form, right? Next one was the checklist. Checklist is more or less same, but what excess checklist takes, checklist also gives you a column whereby you have to jot down the jurisdiction, that is the police station in which your complaint lies. It means at which place the offence has been committed. So जिस जगह पर offence आपका commit हुआ है, that place is to be considered as the place of jurisdiction for the magistrate to try. Third thing, that is index, which is very important. Index is very important. Why index is very important? Suppose you are a judge, you are sitting on the podium and you have a piece of paper with you, a bunch of piece of papers with you, whereby we cannot understand that what is and which paper is where. So for that aspect, index is very much required. Even if you read your books, the first page is your index. Even though you are reading the manuals with the bare apps, you have your index with you, that this section is at page number this, so that you can swiftly save your time and get into the rules where you actually want to be. Okay. Next thing, that now the complaint starts. First is memo of parties. Now what is memo of parties? Memo of parties का मतलब होता है कि जितने भी लोग इस केस के अंदर involved हैं, means the parties to the case must have their full identifications before the court, so that court should know the specification of each and every party. अब एक छोटा सा एग्जांपल है. I have started my practice during the early days of my practice. I have drafted a complaint. मैंने अंदर बहुत वर्ड्स का ब्यूटिफिकेशन किया और बहुत अच्छी चीज की. बट मेमो ऑफ द पार्टीज में व्हाट आई हैव रिटन डाउन, जो रिस्पोंडेंट्स थे, आई हैव रिटन XXX son of YYY, एड्रेस नियर पीपल का पेट, नरेगा है. तो नाउ अगर हम देखें, एड्रेस इज करेक्ट. There is no harm in address because there are lots of people who have the address. But what law says, or what the rules and regulation says, that जब भी आप address provide करेंगे, provide a specific address. If you have a house number, you should give it a specific house number. If you have a ward number, you should give specific ward number. Then gully number. So that the judge should point out, or the person who is sending or who is delivering the summons should point out that yes, this is the thing, this is the place, and this is the place where you have to deliver the summons. That is why it is very important. And nowadays, Delhi High Court, Honorable Mr. Justice Rajiv Shankar has passed a judgment whereby he also says that the delivery of summons by way of WhatsApp, by way of email ID, emails, or by way of any other electronic mode, whereby you can ascertain that yes, delivery has been done, or also a valid mode of services. So for that purposes, it is all okay. Next thing is the paper which we usually, which a trial court advocate usually skips. कहते हैं कंप्लेंट तो फाइल कर ही दी है, तो इसका लिस्ट ऑफ डेट्स एंड इवेंट्स का ये सिनॉप्सिस का क्या फायदा है? I tell you very interesting aspect of this. There are there are two three friends who have become judges now. They we were talking with each other. So this is कि हिमांशु, frankly speaking, हम लोग ना कंप्लेंट्स कई बार नहीं पढ़ते बिकॉज बर्डन इतना होता है आजकल जजेस के पास. दिल्ली, आई एम टॉकिंग अबाउट दिल्ली जजेस, एमएम्स, they used to have 110, 120, 130 cases a day. So they usually says कि Himanshu, it is not possible to read 150 cases a day. So sometimes we skip the reading of complaint. तो एक एडवोकेट के लिए वहां पर थोड़ा सा माइनस पॉइंट है बिकॉज समटाइम्स कोर्ट्स में इतना टाइम नहीं होता है और समटाइम्स जजेस के पास या एडवोकेट्स के पास भी इतना टाइम नहीं होता है. वी कैन टेक द प्रेजेंट सिचुएशन. Now the COVID is running out, right? We all have to do our works through this webinar or through this Cisco WebEx or video conferencing. So what is being written in your paper is very important. So usually मैं अपना एग्जांपल ले लेता हूँ. जैसे आई एम सोलर एप्लीकेशन, टू बी वेरी फ्रैंक, आई एम एडमिटेड. उसमें क्या होता है, कैन टेक अ easier way. Okay, if the list of dates and events are given, that this had happened first, on first, this had happened on second, on third, on fourth, on fifth. So this gives an overview to every judge. That also seems to be a good gesture of drafting. That the advocate knows the advocate knows that how the synchronization of events are doing. And the next thing is synopsis. When you find the synopsis, the picture in the mind of every judge is very much clear without even reading the main complaint. That yes, this is so, and that is why this all has been done in this particular case. So that's why it is very important to get into the list of dates and events and to get into the synopsis. I'll give you a suggestion. जब भी कोई भी केस फाइल करें, बनाते वक्त वकील deems you have to draft it like an advocate, and then you have to recheck it, check it like a judge, so that you could point out the mistakes, and your complaint is the base of your case. The complaint can be used as a corroborative, as a contradictory evidence against you people. So that's why always draft your complaint as an advocate, as your master of your case, and always check your complaint as you are a judge and you are there to throw it out. तो आपको जज साहब को मजबूर करना है उस कंप्लेंट पे आपको वो रिलीज देने के लिए जो कि आप चाहते हैं. नाउ कमिंग टू द कंप्लेंट, द मेन आस्पेक्ट. कंप्लेंट के अंदर तीन चीजों का हमेशा ध्यान रखें. First, who is complaining and why this complaint has been filed by this complainant. That needs to be very much apt and clear. So that the first point which strikes to every judge is that whether the person who is standing before me has the locus standi to file this particular complaint. So once locus standi is clear, one doubt goes away. Next, your contents, that is the body, that is the facts of the case. CPC सबने पढ़ा है, CPC में order 6, order 7, order 8. Right. I'm not mixing it, but I'm just giving you an example so that the things would have been much clearer. वहाँ पर एक term use होती है factum probenda and factum probentia. That you need not to state the law, or rather you need to state the facts. That factum probenda is very much, factum probenda and factum probentia is very much applicable in the complaint source. Here you need not to state the law, but rather you have to state the facts which had occurred to you, so that the facts should show to the judge that yes, some offense has been committed by the respondent, and thereby he needs to be tried and punished or prosecuted for the particular offense. So in that regard, what the things which needs to be keep in mind, first is the chronology. Chronology is very important. अब क्या हुआ, एक तारीख को, suppose I'm giving an example, it would have been clear to you. 1st of January 2020, I was going somewhere and I have saw that a person was stealing something. Sorry, an ex-person was stealing a pot from Y's house. Now, in the meanwhile, when I turned back, the ex was also stealing the purse, and he, while he was fleeing from there, he hit the flask on the head of Y, and while he was going away, he locked the door of X house, of Y's house. So the chronology should be in itself, should be like that only. अब इसमें ये नहीं करना कि Y ने भागते भागते दरवाजा लॉक किया, पर उससे पहले उसने ये किया, पर उससे पहले उसने, you should not go in descending order, in the reverse sense. You should be going in a story form, in a free flow, ताकि it should be, जब आप जज को कोई कहानी, जब आप किसी को कोई कहानी सुनाते हैं, तो it should be like कि आज ये हुआ, कल ये हुआ, परसों ये हुआ, उसके बाद ये होता चला है, so that it should be water flow, और जो सुनने वाला है उसको भी थोड़ा मजा आए. That is why a complaint should be written in a chronological sense, ताकि जज साहब जब उसको पढ़ें, when a complaint is to be read by a judge, the judge should understand that yes, this was the beginning and this was the end. अब इसमें मूवीज की तरह नहीं कर रहा कि भाई 3 Idiots में पहले कुछ दिखाया था, बाद में कुछ दिखाया, फिर कुछ दिखाया. The complaint is not a 3 Idiots movie. The complaint is a flow which needs to follow. It needs to be a waterfall which is coming from upwards and going till your sea. Next aspect is the important aspect. That is your prayer, and that is what which was being discussed in section 2D. That is your mind, or that is you, with a view of taking action, until and unless you pray that the person should be prosecuted and tried for such and such offense. Your intention to prosecute the person is not clear with the complaint. And if your intentions is not clear, then you are missing the very essential of complaint, and therefore it will remain to be an information. It cannot be considered as a complaint. The last one is the verification, that you have to verify each and every paragraph, that this paragraph is in your personal knowledge and this paragraph is being referred by advocate or given on the basis of the law or whatever so you follow. So these are the basic things which you keep in mind while filing the complaint. Yes. Now coming to one more important aspect. Uh, I have gone to state commission once. It was way back in 2013, 2014. Uh, Mr. Gupta was sitting, Mr. O.P. Jain and Mr. Gupta's bench was sitting there. So an advocate stand up and he has filed a complaint. So he was arguing before the bench. So that at that time, Mr. Gupta says, वकील साहब आप जो बात बोल रहे हो ये आपने कहीं पर लिखी तो नहीं है. So counsel replied, Your Honor, whatever I am speaking is in the annexures which I have annexed along with the complaint. So Mr. Gupta says, Honorable Gupta says, yes, but have you written it in your complaint? Have you anywhere shows that this annexure simplifies this particular thing which you have written? So what the counsel replied, counsel says, but my lords, it is the rule of the prudence that every annexure is to be read in toto with the complaint, and it is to be considered as part and parcel of the complaint itself. So honorable judge says that yes, it is true, but you need to specify it, and that is what the basic decorum is. See, it is always better to read the mind of a judge. Ultimately, judge will be giving you the relief on the basis of what you have written in that complaint. So you should be very much clear. मेरे सर कहा करते थे यूजुअली कि आप जब भी जजेस को कोई भी कंप्लेंट या कोई भी एप्लीकेशन फाइल करें, यू शुड नॉट फाइल इट बिफोर अ जज. You should file it that you are teaching to a law student who has just entered into law school. कि आपको उनको सिर्फ खाना बना के और परोसना नहीं है. You have to उनको खिलाना है with your own hand. So it's better you should give them all the things which you yourself as judge requires that you should be having in your plates. तो annexures के अंदर जो भी कुछ लिखा है, always give a brief, concise in your complaints, and always mark that this thing is being written in this particular annexure. That will give a very glimpse of what the annexure is all about. I'll give you a passing reference to it, and then I'll be moving further forward. When we file an application under 156 clause 3, that is for filing for lodging of an FIR, right? So in that case, what always be done, that Honorable Supreme Court said in the judgment that in Sakiri Vasu versus State of UP 2007 Supreme Court judgment delivered by Honorable Mr. Justice Markande Katju and Madam Gyansudha Mishra, the judgment was very clear, and judgment has provided that if an FIR has not been lodged, that what are the remedies available to you to the victim. So in that regard, filing of application under section 156(3) is also a remedy available. So in that regard, what you have to do, there was a recent judgment on this particular aspect, that is Priyanka Srivastava versus State 2015 Supreme Court, whereby Honorable Supreme Court has said that you need to file affidavit with all the applications you are filing with respect to section 156 clause 3. But what is that affidavit is all about? Affidavit says that you have fulfilled the condition of section 154 clause 1, section 154 clause 3, read along with section 36 of CRPC. Why I am giving this? Because here, when you are filing a complaint and you are saying that this complaint has been filed, but before filing this complaint, I have exhausted this remedy. So until and unless you write it down in the complaint, how would judge apply his mind that the agencies before which you have given the representation has made a false or has not done their duty to the very extent so that you could have your remedies available then and there. So it is very much important for all of us when we are filing a complaint that we should be knowing that what are the basic contents of a complaint while filing or while getting it filed before a registry. अब मुंशी जी तो उसके ऊपर टिकट लगा देंगे 2 रुपए की या आपका वकालतनामा फिल कर देंगे आपसे सिग्नेचर्स करा लेंगे बट द थिंग इज दैट अल्टीमेटली द ड्राफ्टिंग वर्क हैज टू बी डन बाय एन लॉयर राइट so this is all about for filing a complaint in the general offences that is with respect to IPC and all. So now I'll be discussing filing of 2 more types of complaints. First is filing of complaint under Negotiable Instruments Act because it is a very wider scope nowadays it is going on. And second is filing of complaint before a CAW cell or a metropolitan magistrate or of a judicial magistrate first class, that is a Mahila court which usually we found it in metropolitan areas. So first we'll be dealing with filing of complaint before filing of complaint in Negotiable Instruments Act. Now the first 3 documents remains to be the same. First is checklist. First is the case information report form, and second is the checklist, and third is the index. Now, what is there in the index? Index के बाद वाले documents. Again, memo parties. The second document is the list of dates and events. The list of dates and events are very important in this case. ये in fact जो basic complaints थी उससे भी ज़्यादा important हो जाता है. क्यों? Because the offence under 138 is time specific. There are numerous judgments. There was judgment of K. Bhaskar in this case. There was judgment of Nishant Agarwal in this case. There was just recent judgment of Dashrath Roop Singh Rathod in this case. All these judgments gives you one glimpse, one common glimpse, that the offence will be committed after sending the notice, and the notice has been received, and even though after the expiry of the time that is of the requisite notice period expires, but still the payment has not been. So the chronology should be shown, should be inferred in your complaints. So therefore, list of dates and events are very important in this filing of complaint of one negotiable instruments. Coming forward, the next document. Next document is Honorable Delhi High Court passes judgment in 2010, whereby it is necessary to file 2 affidavits along with 138 complaint. First is affidavit of confirmation of address, that the address which you are giving of the accused person is correct and best of your knowledge. Because क्या होता था पहले, there were some cases which were being found by Honorable Delhi High Court, and that's why the judgment came in action. कि complainant क्या करते थे, complainant address file करते थे, XYZ कोई भी address file करते थे. It was found that the person is not residing. और क्या होगा? I'll give you in common sense. I'm Himanshu Jain and I'm residing a certain. I'm residing suppose X address, right? क्या हुआ? There was a person Y who has given a check to A person. A के पास वो check bounce हो गया. A has filed a complaint. A has given address of mine, that is XXX. What A has filed a complaint. A says A, his address is so and so versus Y address is XXX, but the address of XXX is mine. So अब क्या होगा? मेरे पास अगर कोई सम्मन आता है, so what should I be saying? कि यहाँ पर ऐसा कोई नहीं रहता, या I don't want this particular thing. So in some cases it was being found that it was being written on the summons that the person has refused to take summons, and therefore it prejudice to the rights of Y itself. Thus, the affidavit of confirmation of address proof is being filed along with the complaint. अब एक क्वेश्चन उठ रहा होगा कि सर अगर ये कर भी दिया और अगर गलत एड्रेस का भी एफिडेविट दे दिया, then what is the remedy available to the accused person? The remedy available to the accused person is to prosecute the complainant for filing a wrong affidavit, and court do have the right to take summary action against a particular complainant for filing a wrong affidavit before the court. अब जो affidavit होता है, that is to be on the attestation of court commissioners. So when you are giving an affidavit on oath, it means आपने कोई भी चीज कोर्ट में oath पर बोली है, and if you are saying something on oath before the court, you are liable for perjuring that oath. Right. The next affidavit which is to be filed along with this is the affidavit of confirmation of the proceedings which have been done. That all the proceedings have, along with the simultaneous time, has been done here, and therefore this affidavit has been filed. Next, coming to the complaint. The complaint should contain 5 basic essentials of every the offence which has been committed, that is under negotiable instruments. First, the check has been issued against the liability. So you have to show that this was the liability which is due against the particular the accused person, and therefore this check has been issued in lieu of that particular person. Afterwards, that the check which was being presented well within the local jurisdiction of the court before which it is being filed for trial. Third aspect, that the check was being dishonored on such and such day, and after dishonoring it, the legal notice has been filed within the stipulated period of time. Next, and the foremost essential, which will constitute the crime, which will constitute the offence, is that the notice which has been issued has been delivered, and still the payment has not been made. So all these things, all these essentials, you should be showing while you are filing the complaint under section 138, read with section 142, read with section 118 of negotiable instruments. Right. So the last 2 or 3 paragraphs, the 3 paragraphs which you always include, the first is the territorial jurisdiction, the honorable court has a territorial jurisdiction. The second last is the peculiar jurisdiction is always lies with the court, right? And the subject matter jurisdiction. And the third one is the requisite court fee has already been paid, and therefore this honorable court has the jurisdiction to try the matter. And along with that, there will be a verification clause beneath it to that particular complaint, which will verify all the contents which I have mentioned in this particular complaint. So now, which documents you have to annex along with the complaint. The basic documents I am telling, and rest you, as you wish, you can annex it. First, the document which establishes the liability. That is the basic document. Second, suppose there was a commercial transaction, so you do have the bill which you have issued to that particular person. So you always have to annex that particular bill along with the complaint. Second is the original check. Third one is the bank memo or the bank advice or the returning memo which you call. Fourth document is the legal notice. Fifth document is the sending receipt. You are sending it by way of speed post, or you are sending it by way of courier, so you have to annex it. Next document is your proof of delivery, your delivery proof that you have to annex along with it. And next is very important document, that is a certificate by the complainant by virtue of any electronic document which has been filed. You have to file it along with that particular complaint itself, so that you should not rush afterwards. Uh, High Court rules of Delhi also states, it says that evidence for negotiable instruments act, the complainant, जो complainant की tendering होती है, I'll just make it very simpler to those who are not acquainted with this term. Tendering का मतलब क्या है? लॉ कहता है कि जो डॉक्यूमेंट कोर्ट की फाइल में एग्जिबिट नहीं होगा वो नहीं पढ़ा जाएगा. बट बुक्स में तो हम ऐसा कुछ पढ़ते नहीं. बुक्स में तो हम सिर्फ प्राइमरी एविडेंस और सेकेंडरी एविडेंसेस के बारे में पढ़ते हैं, या फिर हम एविडेंशियरी वैल्यू ऑफ एविडेंस के बारे में पढ़ते हैं. बट दिस इज द प्रोसीजर. इट सेज कि जब आप कोई भी डॉक्यूमेंट कोर्ट में सबमिट कराते हैं तो कोर्ट को कैसे पता चलेगा कि that you are relying on that particular document. So for relying and to ascertain that yes, this document is valuable for determining the correct facts of this case, the party who is filing the document needs to exhibit the document. Exhibit का मतलब क्या होता है कि you have to tell to the court that sir or madam, your honor, your lordship, that I am relying on this particular document to prove the guilt of the accused. Therefore, usual course में क्या होता है, हम रेड पेन से exhibit, उसके बाद जो भी विटनेस का नंबर होता है, if prosecution witness is coming, जैसे यहाँ पर complainant है, complaint file में, it will be complainant witness. So what will be writing? Exhibit CW, that is complainant witness 1, first witness ऑब्लिक उसका डॉक्यूमेंट नंबर. अब जैसे कि क्या हुआ, हमने सबसे पहले क्या फाइल किया, हमने सबसे पहले बिल फाइल किया था, तो सबसे पहला बिल विल बी एग्जिबिट CW 1/1, राइट. उसी तरह से चेक आ जाएगा एग्जिबिट CW 1/2. नाउ व्हाई इट इज 1? बिकॉज दीज डॉक्यूमेंट्स आर रिलेटेड टू कंप्लेनेंट्स फर्स्ट विटनेस. तो जैसे जैसे विटनेसेस, अब जैसे अगर सेकंड विटनेस आता है और वो कोई और डॉक्यूमेंट लेकर आता है तो इट विल बी कंप्लेनेंट विटनेस. अब जैसे कि क्या हुआ, आई गिव यू उसके लिए, जैसे कि क्या हुआ, नाउ वी हैव कॉल्ड बैंक ऑफिशियल कि भाई मेरा बैंक स्टेटमेंट लेकर आएंगे और जो मेरा चेक बाउंस हुआ है उसके जो चार्जेस लगे हैं, सो दैट द कोर्ट शुड बी कंफर्म कि यस चेक बाउंस हुआ है. तो बैंक विटनेस को मैंने बुलाया, तो बैंक विटनेस आया, आने के बाद नाउ द डॉक्यूमेंट, अब वो मेरी बैंक स्टेटमेंट लेकर आए हैं, माय बैंक स्टेटमेंट विल बी exhibit CW 2/1, that is second complainant witness came and he has given this particular document, right. So this will be the case in filing of negotiable instruments. So now the third one is, that is filing of complaint in under section 12 of domestic violence, protection of female against domestic violence. What it says that a complaint will be filed. There are two procedures with respect to it, but first one is more prominent and second one is bit different. First, CAW cell के पास complaint जाती है, so that is not a complaint for a magistrate because CAW cell में who are presiding over the police officials who are presiding, but therefore it is to be done by way of police rules and regulations. तो अगर वहां पर केस सेटल नहीं होता है, then the matter, what do? They write down a note before afterwards that complaint that the matter is not been settled and the matter is fit for lodging on a FIR. So they lodge an FIR. So after lodging an FIR or before lodging an FIR, the complainant do have the right to move to the magistrate by filing a complaint there. So now what that complaint should cover. Now that is important because there are lots of complaints which are being dismissed on this very essential aspect. The documents remains to be the same. Only सिर्फ एक चीज का डिफरेंस आता है, and that is very important difference. क्या होता है कि when advocates draft the complaint under section 12, तो जो victim lady ने बताया, they jot down all. But sometimes what is being left is the specification of the offense offense committed by the respondents. I'll give you an example in that regard. क्या होता है कि हस्बैंड और मदर इन लॉ और फादर इन लॉ के अगेंस्ट में दे आर एलिगेशन स्पेसिफिक एलिगेशन बट समटाइम्स द साइकोलॉजी ऑफ एडवोकेट सेज कि जो ननंद है उसको भी पार्टी बना दो या जो कोई देवरानी है उसको भी पार्टी बना दो so that it should pressurize the husband side to an extent and they should be the female side should be the complaining side should be on the higher side. But what do judges say? Judges कहते हैं, judges see or what do say? They see that is there a specific allegation or specific fact which states that the respondent has done something wrong against that particular lady. Sometimes answer is yes, sometimes answer is no. I'll give you an example on that. I was dealing with a case in 2000 and way back in 2010. क्या हुआ? Lady ने पूरे घर वालों को पार्टी बना दिया. There were 7 or 8 odd members in the family, and she has made all of them the respondent. उसमें सास, ससुर, हस्बैंड, दोनों नन उनका क्या कहते हैं उनके जो जेठ थे, जेठानी थी, देवर थे, she has made all of them part. So while the complaint was on record, the judge pursued the matter and she didn't find she found that there was specific allegation against only 3 persons. That is husband, mother-in-law and father-in-law. So she says, the judge says that yes, why you have made all other persons party? So she says, the counsel says that your lordship, there are all the persons are involved in this matter, and afterwards, what is being found out that 3 of them has never visited to the house after the marriage has been solemnized. So in that regard, they require discharge because the complaint does not say about them. And when complaint does not say anything about them, then how can they be prosecuted for that particular offense for which they have not done anything? So being as an advocate, being as a counsel, you always keep it in mind that the complaint should have all the specifications, against all the accused persons in that particular thing. Right. So, without taking much of your time, I'll just left with only one topic which I need to discuss under the case laws in particular. That is amendment of a complaint. Order 6 Rule 17 and Order 6 Rule 18 CPC. There is a specification. Yes. सिविल लॉ में देयर इज स्पेसिफिकेशन कि हाँ जी 617 और 618 सीपीसी के अंदर अमेंडमेंट होती है बट डू एनी ऑफ द प्रोविजंस ऑफ सीआरपीसी स्पेसिफिकली enumerates that yes there should be an amendment in complaint. There is no provision. That's why I'll quote a old saying of Honorable Mr. Justice Krishna Nayyar. He says that when something is given to you to do ancillary is also given in that particular. Means thereby that when the complaint itself is there, so for amending the complaint, the part to amend the complaint it is itself there in section 200 CRPC. But that is subject to some conditions. And therefore the judgment of S.R. Surkumar versus S. Sunar Raghuram. I may just read the judgment for you people if you want to jot it down. S.R. Surkumar versus S. Sunar Raghuram, criminal appeal number H44 of 2015. Judgment delivered on 2nd of July 2015 by Honorable Supreme Court. There are only 4 major points which I'll be discussing and then I'll be leaving you people. The first one is Yes, amendment is allowed, but first thing, that the cognizance should not have taken by the magistrate. I'll tell you very frankly for this, because once cognizance has been taken, process has been issued to the other party, then in that case, if amendment is allowed, it will prejudice to the other party, that is to the accused. Why? Because review is not a remedy in criminal law. Therefore, it needs to be, therefore, amendment aspect needs to be used very sparingly. Second thing, amendment is a consequence of subsequent event, thus avoiding multiplicity of proceedings. Suppose I have filed a complaint and before issuing of process and after filing of complaint, some event occurs, or even after issuing of process, some event occurs, and that event is very much required to be inducted in this particular complaint. Otherwise, it would be it would be a further remedy for filing a further complaint. So for clubbing that multiplicity of cases, we need or we require to allow that particular amendment. Third, the most important chapter, which is there in Order 6 to 17 also, and which is there here also, that it should not change the nature of the complaint. मैंने इनिशियली फाइल तो किया डिफर्मेशन का केस, बट मैंने जब अमेंडमेंट किया उसके अंदर, then it becomes the case of cruelty, or then it becomes the case of bigamy or adultery. That should not be the case. And the fourth one is the very important aspect, that is that the amendment should be unambiguous. Means पहले तो मैंने चीजें बहुत साफ साफ लिखी थी, बट सडनली आई रियलाइज कि मैंने जितनी साफ साफ चीजें लिख दी, it might go against me in the evidences. So I filed an amendment and मैंने उन चीजों को गोलमोल कर दिया. In that regard also amendment is right. So with this, I am over with whatever the topic is being given. I have tried to justify the topic with me. So over to you guys.
Sir, is there any difference between Wakalatnama of District Court, High Court and Supreme Court?
There is not much difference, but there is a difference before Supreme Court. High Court and Trial Court remains to be the same, but before Supreme Court, as we all know that the only advocate on records have the right to file the cases before the Supreme Court. Therefore, there are some characteristics difference. Otherwise, there is not any basic difference in filing of Wakalatnama for Trial Court or High Court or Supreme Court. But there are some basic difference that the registry wants that it should be in this particular format and it should not be in this format. But whereas for Trial Court and High Court are concerned, that you have your own right, that your own performer by virtue of which you can file the Wakalatnama.
Sir, I want to ask one more question.
Yeah.
We are discussing about the procedure to file a criminal complaint. So the procedure of filing a civil complaint is also same, or is there any difference?
My dear, when you file it as civil complaint, there is no word which is called a civil complaint.
Okay, okay.
It will be either it will be a plaint or it will be an application.
Yes, yes. So the procedure is same, na?
No, the procedure for civil is different. It has to be as per Order 4, Rule 1, Clause 2, read along with Section 26, read along with the High Court rules of the concerned state.
Okay, so it will be done according to CPC, provisions of CPC.
Yes, exactly.
Okay. So I hope that you guys, I hope that you understand all the things. So can we conclude, sir?
Yeah, sure.
Okay. So thank you so much, sir. आपने इतना टाइम दिया हमारे चैनल के लिए, थैंक यू सो मच।
थैंक यू।
ओके, सो वाइंड अप करते हैं।